A very good afternoon and welcome to another episode and session of Lunch and Learn. And today we will be discussing anything and everything about attachment orders. That includes now warrants of execution as well as attachment for debt, which we find quite often when it comes to enforcement of maintenance orders. So what we will be looking at today or discussing today, if we can just give you a quick rundown of what we will be discussing, is obviously how and when one can apply for a warrant of execution that could be granted by the magistrate or the maintenance magistrate for enforcement of arrear maintenance. We will also be discussing some legislation and some case law that pertains specifically to attachment orders, and then answer the question of, what type of items may be judicially attached to secure payment of arrear maintenance, and what items are specifically excluded by the Act that cannot be attached. We will also ask the question, what would happen if the respondent owes nothing or owns nothing to attach? And just give you a rundown on the explanation of the procedure that needs to be followed in order to obtain a warrant of execution. We will also be discussing the issue regarding costs and the assistance by the state of paying for the warrant of execution, as well as a couple of general tips on how you can fast track your maintenance matter with regarding the issue of a warrant of execution, as well as an attachment order. Some logistics, what can you expect from this webinar? Obviously, if you have registered on our webpage, what's the website now? I forgot the website, lunchandlearn.org.za, then you would have received the link to come to a web page where you would find some pre-reading material. If there's any pre-reading material, it will be on the tab called pre-reading material, a live link to this webinar that you can watch afterwards as well. And then most importantly, the resource and templates folder. Now, in that folder, you would have where you could download a copy of the slides that we will be using, as well as a course handout that will contain all the information that you need and that was discussed during this webinar. So without further ado, if we could just have a look and maybe have an overview of what types of remedies are there that you could ask for if the respondent is in arrears. Now, obviously, we're talking about arrear maintenance, which is governed by Section 26 of the Maintenance Act, where it says that the enforcement of maintenance orders, whenever a person against whom an order was made fails to make such a payment, then you can approach the court to give you an order together with interest thereon to ask for either a warrant of execution against property or the attachment of an emolument, like we discussed previously, as well as an attachment of debt order in terms of Section 30. Now, these are the three options that you would have available if the respondent is in arrears. One needs to take cognizance that the Act is very clear that only one of these methods could be used. So you could either apply for a warrant of execution against property, or you could apply for a garnishee or emolument attachment order where they attach the salary of the respondent, or you can ask for an attachment of debt as contemplated in terms of Section 30. So you cannot use all three of those. You have to choose one of those that is the most applicable to your situation. You cannot choose all three. Now, the South African Law Reform Commission is busy with a process in paper 157 to make recommendations that more of these options could be used running simultaneously, so that if you have a garnishee order and they default in the garnishee order, that you would also be able to issue a warrant of execution against property, and the one that would not be precluded from the other one, so that you have to use only one. The problem that we have in practice in the maintenance court specifically is that, say for instance, there is a garnishee order that is running and the respondent is in arrears with the garnishee order, and you want to approach the maintenance court then for a warrant of execution against the movable property of the respondent, is now that the garnishee order, the emolument attachment order, first needs to be terminated or suspended before you could make use of the provisions of Section 27 that deals with the execution against property. So bear that in mind, that it's not a simple process just by going through to court and just asking for a warrant of execution against property if there is any other remedies that is already in use, which is most oftenly the garnishee order or the emolument attachment order. But for today's webinar, we will be dealing with the execution against property as contemplated in Section 27 of the Act. Now, Section 27 of the Maintenance Act says that the Maintenance Court may, upon application of a person referred to in Section 26(2)(a), which is obviously the complainant, authorize the issue of a warrant of execution against the movable property of the person against whom the maintenance order in question was made. And if movable property is insufficient to satisfy such an order, then against the immovable property of that latter person. And the amount that needs to be recovered is the amount that he has failed to pay, together with any interest thereon, as well as the cost of the execution. So if one unpacks Section 27 and we take it bit for bit and we take it apart just to unpack that, we will see that there's a couple of things that is addressed in Section 27. Number one, to start off with, what is a warrant of execution? It's an attachment of movable property or property that is also authorized by court. The Section 27 also speaks about how do you apply for a warrant of execution. And in terms of Section 27, it is clear that it is upon application, and we'll deal with that in a couple of minutes. Section 27 also deals with what goods could be attached. And it's clear from the wording from Section 27 that first you need to attach the movable property of the respondent, and only afterwards you can apply to court to have immovable property, such as a house or a holiday home or something like that, and immovable property to have that attached. But you first have to exhaust all the avenues by attaching the movable property. And that is all dealt with in Section 27. For what amount? Act is very clear. It says it is for the amount that he is in arrears for. That would actually mean that there is a maintenance order in place. You cannot apply for a warrant of execution against property if there is no valid court order in place. So you cannot just rock up to the maintenance court and say, okay, right, you know what, he owes me money, he has not been paying, and there is no maintenance order, and now you want a warrant of execution. The Act is very clear in Section 27 that this is a method of enforcement of arrear maintenance. So there needs to be a maintenance order in place before you could make use of Section 27. Also very important that we do not use quite enough and that you are entitled to is that you can claim the interest and the cost of the execution from the respondent. The Act is very clear that that provision is there and it is available, that you can claim interest on the arrear amount together with the cost of the warrant of execution. So how does it work in practical terms? We all know that a warrant of execution is basically a court order that has been ordered by court, and the court would grant a warrant of execution. Now, warrant of execution, the writ of execution, as it is also known as, is simply a document that allows the sheriff of the court to go to the respondent or to the defaulting party and to go and take some of his furniture, in layman's terms, some of his furniture, some of his movable assets, in order to be sold by public auction to give you the money that is due to you. So there's a couple of role players in this whole scenario of Section 27, the attachment and the warrant of execution process. First of all, you would have the applicant. Now we're just talking about the parties that are involved in this whole process. First of all, you would have the applicant, that is usually the complainant, the mother that claims maintenance, and she needs to apply to court for a warrant of execution. There's a simple process that needs to be followed, and then the maintenance officer will take that matter further and investigate that matter in terms of Section 6 of the Act, and then proceed with with an inquiry as to which is the most suitable remedy that you could find or that they could utilize in order to recover the arrear maintenance. And that's usually either the emolument attachment order or the warrant of execution. But we're dealing with the warrants of execution at this stage. So the court also becomes involved where the court authorizes the granting of a warrant of execution against property. It's actually very strange because in normal civil litigation, the process would be that you simply, if there is a default order or an order of court, that you can simply apply to the clerk of the court in order to grant a warrant of execution without the need for formal appearances and so forth. And that is also amplified in Section 24 of the Act, where it says that any order of court is basically the same as an order of court in a civil matter. The reason why, and it's my submission, it's why the legislator brought this in, is because of the provision of Section 26, where they speak about what avenue, what remedies there are available, that you can only choose one of the remedies. So it does not necessarily say that the magistrate or the maintenance court would grant you the warrant of execution, but they merely just simply authorize that after they made themselves aware that there's no any avenues being sought, like, for example, a attachment order for debt or for a garnishee order. And that is the reason why the magistrate would only authorize at that stage the warrant of execution against property. So the court would definitely become involved because we need a court order in order to give effect thereto. And then that order goes through to the sheriff. And there the maintenance officer is also instrumental. The Act speaks of the service of the document. So the warrant of execution needs to be served, and needs to be processed, and needs to be formally served upon the respondent. And that's usually done by the sheriff of the court or the maintenance investigator. But we found that in very little cases, the maintenance investigator is used to effect the warrant of execution against property. So the sheriff will definitely become involved. The sheriff would visit the house or the property of the respondent in order to judicially attach some of the goods. Now we'll get to what goods can be attached, what cannot be attached, and so forth in a while. So the sheriff is also involved in this whole process. After the sheriff now has judicially attached those documents, or those, in terms of the warrant of execution, those items that he deems attachable as movable assets, then those goods need to be sold by public auction. And the reason for that is it is an open auction, so anyone can bid on that. And then ownership would transfer to the new owners, and they would pay money for those goods of the respondent. The proceeds thereof, after the sheriff then has deducted his cost, obviously, for the sale and execution, would be paid over to you as the complainant of the and having the order. What would also happen is that very often, because it's not cast in stone for how much the goods will be sold. So what we see in practice is that very often the amounts that the sheriff attach is not enough. The goods that the respondent has is not enough. So the question would be, can you apply for another warrant of execution if you find out that there's more assets that could be attached? And the answer there to is absolutely yes. You could do that. A defaulting order would stand for a period of time, and it would be well within your rights to apply for an additional warrant of execution should you find that there are more items that the sheriff could attach. So how does it all work in practice? Like we said, that the normal instances would be where you would use that is, in terms of Section 27, is an enforcement tool for arrear maintenance. So you would go to court and you would fill in a J306 form, Form K J306, which is basically an application for the enforcement of maintenance. Because he's in arrears, you fill that document in, and then you have to hand that over to the maintenance officer. The details, obviously, you need to to supply as well. That is the amounts that are in arrears. So if you do have banking statements where he had to pay it in your banking account and he's not been doing so, take along your banking statements, all those documents that is necessary for you to prove that he is in arrears and that he still owes you that money. Usually what happens is that in terms of the Act, a period of 10 days needs to lapse before you can apply for a warrant of execution or any of the avenues mentioned in Section 26. We suggest to our clients that you fill in an affidavit or you complete an affidavit at the police station, identifying your banking statements and setting forth to court the total amount that is due, that you want a warrant of execution to be executed for, so that the court would be in a position to say, but you know what, this is the amount of arrear maintenance. And then that documents together with your affidavit and the J306 form needs to be given to the maintenance officer. And then you could also ask the maintenance officer specifically, because remember there are three things that they can include. You can ask for either a garnishee order, emolument attachment order, or for an attachment of debt, or for a warrant of execution. And the maintenance officer might not know the specific details of your matter. So you would know what type of property does the respondent have. So you need to guide the maintenance officer to say, you know what, he does not have a fixed work, or he is not gainfully employed, but he does own cars or vehicles or house or property. And then the route would be to go for a warrant of execution against property. But you have to guide the maintenance officer with regards to that. Obviously, then the court would grant or to authorize the warrant of execution, and we've dealt with that a couple of minutes ago. So if we look at the inner workings of what does Section 27 say? And it says that a warrant of execution authorized under that section by the magistrate shall be prepared by the complainant. And we'll be unpacking this word for word or section by section. So the warrant of execution that has been authorized by the court needs to be prepared by the complainant. It needs to be issued by the clerk of the court in the manner prescribed, and it needs to be executed in the prescribed manner by either the sheriff of the court or the maintenance investigator. And then section B, 27(2)(b) says that the complainant shall be assisted by the maintenance investigator or the maintenance officer in taking the necessary prescribed steps in order to give effect of the warrant of execution. So if we unpack section 27(2), it clearly says that the warrant of execution, after it has been authorized by court, needs to be prepared by the complainant. So there's a responsibility on the complainant in order to prepare the documents. So it's not expected by the courts that the complainant or the lay complainant actually goes out and complete all these forms, because the J397 document upon which the court authorizes the warrant of execution is only used in courts. That is not a downloadable document from the DOJ's website. So the magistrate would, after they authorize that, request the complainant to fill in section A or part A of that, which basically indicates the amount that is in arrears, together with the interest and then the address of the execution debtor or the respondent in this matter. So that is basically what is meant by the documents should be prepared by the complainant. If we go on further, it says that it should be issued by the clerk of the court, the clerk of the maintenance court, in the prescribed manner. That is basically just the same form, the J397. There's a certain portion that the maintenance officer needs to complete, and then the whole document is handed over to either the sheriff of the court or the maintenance investigator for service and further execution. The last portion thereof speaks to the way that it should be executed in the prescribed manner by the sheriff or the maintenance investigator. So the document is literally then handed over to either the sheriff, but in practice, most often it is only the sheriff that deals with these type of matters. So the the document, the warrant of execution, the original warrant of execution, would be handed over to the sheriff of the court. Who pays for the for this whole process? And we'll get to costs in a moment, because there are most courts, or some courts, actually expect the complainant fit the bill for a warrant of execution, the whole execution process, unless they do not have the means to do so. So, in having said that, the cost implications for a warrant of execution is quite huge, because the sheriff needs to go out to the premises or the house of the respondent. They need to judicially attach the goods, and then they have to remove those goods at a certain stage, and usually 10 days before the sale and execution date. And there's also paperwork that needs to go with that. For example, the notice of sale and execution, the goods that have been attached needs to be stored at some place, and those all rank up costs. So the state can, in certain instances, pay for that, and I'll discuss that in a couple of seconds or a couple of slides. But very often, it is expected from the complainant to fit the bill for these type of executionary steps. During the auction, like we said, there's an actual auction that would be held. It would be advertised. It's usually placed on the billboards, on the notice boards at courts, where it says this is the next auction dates, and the sheriff would then sell those goods by public auction and give you the proceeds of the auction after he has deducted his money or his cost for the execution. Very important, like I mentioned quite a number of times before, Section 27(1) clearly states that first the movable property needs to be attached before you can apply for immovable property. So in practice, what would happen in nil bona sheriff return, that is also a word that you might incur while using this process, and that is a return from the sheriff of the court, where they say, a nil bona return, where they say that the respondent has no attachable movable assets. And after they have issued the nil bona, or the non-return or non-service of that, because there is no property to be sold or immovable or movable property, only then you can apply to court to attach immovable property like a house or a holiday home and so forth. I want to refer you to Section 68 of the Magistrates Court, where it says that the messenger, now this Section 68 deals magistrate court for that matter, then, or the sheriff of the court executing any process of execution against movable property may, now this is quite important, may, by virtue of such a process, also seize or take any money or banknotes. So if they have any money stashed underneath the mattress, then the sheriff can attach any notes and checks and banknotes and money as well. And also may seize, take, and sell in execution checks, bills of exchange, promissory notes, bonds, securities for money belonging to the execution debtor. What that basically means is that basically anything that sounds like money or is money can be attached by the sheriff of the court. So it need not only be physical money, but it could also be bonds, promissory notes, bills of exchange, or securities. What also comes to mind is share certificates would also be an attachable item. In a recent case, well, it's not that recent, it's a 2006 case in Soller versus the magistrate Weinberg, that was a 2006 case. The court also held that any pension, annuity, gratuity, compassionate allowance, or any similar benefit that is accrued to the respondent, notwithstanding anything to the contrary contained in any law, could be attached, provided that such pension fund or such benefit or annuity is currently due and payable. So in terms of the Solar case that I just referred to, and a copy thereof is in the resource folder that you can download, the maintenance court obviously has a increased jurisdiction when it comes to the monetary value that is normally curtailed by the magistrate court. So if the person has a annuity or a pension fund, which is more than the amount that is usually claimed by the magistrate court, the maintenance court would have extra jurisdiction to hear that matter. So regardless of the amounts, even if they owe R1 million, where one should usually use the High Court for these type of proceedings, the magistrate or the maintenance court would have jurisdiction to hear that matter. Vitally important is that a proper investigation needs to be done before any attachment is done. And the reason for that is that you cannot attach somebody else's property. That would be grossly unfair and unjust. So if there are any hire purchase agreements or bonds or claims, what the furniture belongs to somebody else and you just loaned it and it's just in your house, but it actually belongs to somebody else, then those type of items cannot be attached. If you have a claim and you attach those type of property which belongs to, for example, a retailer, what you bought on hire purchase in terms of the Credit Agreements Act, you bought a TV or a couch from a retailer, and you attach that document or that property, then there would be an interpleader, which amounts to extra legal costs being incurred, because then the title holder would need to come to court to say, but you know what, you cannot attach and you cannot sell by public auction the stuff that actually belongs to the third party, i.e. the credit provider or the retailer in this case. So if one looks at Section 67 of the Magistrate Court Act that deals with property that is protected from attachment and cannot be attached or cannot be sold by execution. And those type of property includes the following. So bear in mind that if the respondent lives in a little shack and he does not have a lot of worldly possessions, that certain things will not be attached, was not open or protected from seizure and cannot be sold by public auction. And these include necessary beds, bedding, and wearing apparels of the execution debtor or his family. So you cannot attach his bed. You cannot take his double bed. You cannot take his bedding because those are considered necessary items. And it also includes clothing, for example, clothing for him and his family. Having said that, I've had instances where people have expensive leather jackets. Now, that is considered to be a luxury item and not necessary apparel, because the Act clearly says in Section 67 of the Magistrates Court Act that it needs to be necessary and not a luxury. Also, things that is excluded from judicial attachment that could not be attached is necessary furniture, other than obviously beds, and household utensils. You cannot take pots and pans if that is necessary furniture. Obviously, a TV, DSTV, Xbox, and so forth, those would not be considered to be necessary furniture, as well as, for example, a wall unit that serves no purpose. But that could not be attached. But a stove would be considered a necessary furniture, and that would be excluded together with the pots and pans as well. Another thing that could not be attached is stock, tools, and agricultural implements of a farmer. So if you are a farmer, then that would be protected. That's just in order to ensure that he could actually go out and farm and earn a livelihood. Things also that could not be attached is the supply of food and drink in the house, which is sufficient for the needs of such a debtor and his family for a period of a month. I've had cases where where the respondent had a fully stocked bar with very expensive cognac and whiskey and so forth. And that is not considered to be a necessity, and it is not. And they're trying to get through court to say, but that is a protected from seizure, and it cannot be attached. And the court told them that it is an attachable asset because it's not necessary food and drink for at least a month. Another thing that is also important, tools and implements of the trade that could not be attached. So if you are a shoemaker, for example, then all the instruments and all the stuff that you need, tools of the trade, could not be attached. Professional books, documents, or instruments necessary to be used by a certain profession, that could also not be attached. So if you are an attorney, for example, yes, attorneys also get sued for non-payment of maintenance. Then the law books, for example, cannot be attached. If he is a doctor, his professional books and documents pertaining to his specific profession cannot be attached. And then lastly, any arms and ammunition that is registered on that person's name, although it might be an asset, but in terms of the Act, such arms and ammunition that is required by law, and they do have a license for that, cannot be attached. So what would happen is, if the respondent now all of a sudden gets the sheriff knocking at his door and he's unhappy because there are certain documents or certain movable property that has been attached, what are the remedies of the respondent? It's also important to look at that from the respondent side. What is the remedies? And that would also lead up to the case that I will be discussing in a couple of minutes. So in terms of section 27.3, the maintenance court may, on application, that's obviously by the respondent, set aside the warrant of execution if the maintenance court is satisfied that he or she has complied with a maintenance order in question. Now, this is vitally important. So the only way that the respondent can come to court to say, but you know what, I want to terminate this warrant of execution, is if he has complied with the maintenance or the arrear maintenance, and he has paid the arrear maintenance amount. Section 27.4 says that once the respondent has paid and settled the arrear maintenance, he can approach the court to have this warrant of execution set aside. And the court does have certain authorities then. The court may then summarily inquire in a manner and look at the situation of the respondent and the reasons for that. And then the court may make an order for suspension of the warrant of execution, or they could suspend the order and then make together with that an order for the attachment of emoluments. So if he does have a proper if he does have proper employment, then the court may issue a warrant of attachment for debt, for example, or the attachment of emoluments, a garnishee order. That is only if the debtor or if the respondent has satisfied and paid the arrear maintenance. Section 27.5 says that at the inquiry that the maintenance court, the court would take into consideration the existing and the prospective means of the person against whom the warrant of execution has been issued. Of course, the courts will not necessarily just as a blanket decision decide to terminate or to suspend a warrant of execution. There needs to be due course, and there needs to be an investigation or inquiry. And the court would look at the existing and the prospective means of the person against whom the warrant of execution has been issued. The court would also look at the financial needs and the obligation. What is his income? What is his expenses? In respect of the person that needs to be maintained, and also against whom the warrant of execution has been issued. And very strange enough, the court would also look at the conduct of the person against whom the warrant of execution has been issued, in as far as it might be relevant concerning his or her failure to satisfy the maintenance order that is in question, and obviously any other circumstances that the court might deem necessary to have a look at. So the conduct, if the respondent is willfully in arrears and he is just plain, in Afrikaans, they call it harregat, the court would definitely draw an inference on that behavior, and then could use that against the debtor or the respondent when deciding if the warrant of execution should be set aside or not. I want you to refer you to the DOJ Code 26 of 2015, which is basically prescribed rules that is used by the personnel of the Department of Justice. That's basically a guideline that the clerks need to use. And this is now pertaining and leading into the costs. Because, like I said, in most often, it is expected from the debtor to pay the costs for the warrant of execution. But section on page 38 of the DOJ Code, it says in paragraph 41.5, it says that where warrant of execution was authorized by the maintenance magistrate, then the maintenance office should inquire from the parties if they are in a position to pay the cost of the execution. Now, like I said, in a normal instance, these type of executions could run into quite a number, a couple of thousands of rands if there is quite a lot of immovable or movable property that needs to be attached. So the maintenance officer has got a legal obligation to inquire if the debtor or the claimant is in a position to pay for that execution, and if they do not have the funds for that, then the maintenance officer must approach the court with a request that the state would cover the costs of such an execution. It is proposed that the applicant file a supporting affidavit to explain why she cannot afford to pay the sheriff's costs. Now, very often, very little of the complainants coming to court wanting to enforce a maintenance order, existing maintenance order, would not simply not have the means to pay 5,000 or even 6,000 rand for a warrant of execution to be effected by the sheriff. And those events, the state could be ordered to pay that amount. The maintenance officer will then take your request, which is usually then done in the form of an affidavit, and take it to the maintenance magistrate and request the maintenance magistrate to order that the state pays for the cost of the warrant of execution. I want to discuss a recent case. It's an unreported case from the Gauteng court where Judge Shiwendu, it was handed down on the 20th of April last year in 2022. And I actually did an article in the Deribus magazine, which dealt with specifically arrear maintenance and the whole procedure that needs to be followed in terms of Section 27. So what had happened in this matter is there was a divorce settlement and the respondent was ordered to pay 20,000 Rand a month for maintenance for the children. Subsequently, he fell in arrears due to COVID, and he could not pay. The complainant then went to the court. She filed an application. She completed the J306, and she also submitted affidavits of the arrear amount that was still due by the respondent. So that was done by an ex parte application. Now, ex parte application is basically done without the knowledge of the other person. And the court granted that order in terms of Section 27(1) and 2. What happened after that was an amount of over 750,000 Rand was attached and was by the sheriff of the court in terms of the court order from the discovery policy or annuity that the respondent had. So he only had first knowledge of that when he received a a WhatsApp message or an SMS notification, that amount of nearly R750,000 was deducted from his retirement annuity or his policy that he held at Discovery. Obviously, he was not satisfied, or he was not happy about that, and then he started falling in arrears again with the maintenance payments. And at that stage, he was quite a huge amount he was in arrears. And the complainant then notified the respondent, the husband, that they have an intention. They are going to do another deduction from his salary, or not from his salary, from his Discovery policy. And at that stage, the respondent was fairly cheesed off, and he brought an urgent application to court in order to stop that. And he included the Discovery, the financial institution, also as a respondent in order to stop them from making such a deduction. So what transpired in this case, which was quite interesting, in the VDB case, the judge referred to MV versus CV, a 2014 case. And this case is also available under the resource section that you could download. This was a matter that was dealt with in KZN, and the court held that the only jurisdictional prerequisites necessary were that there must be a valid maintenance order, even if it's subject to an appeal, and that a maintenance order against the respondent should be against the respondent, against whom the warrant of execution is sought, and then there should be arrears of maintenance payments, which have remained unsatisfied for a period of 10 days. Now, in this MV versus CV case, Judge Kuhn noted that if the above requirements are satisfied, then the issue of a warrant should be authorized, and it would be up to the party against whom the maintenance order operates to invoke any of his remedies in terms of Section 27(3) or 4. And that basically means that he first needs to satisfy the arrear amount before he can go to court and ask for a suspension or a variation or a stay of the writ of execution. And that was all discussed in the VDB case. So if one unpacks this case a little bit further, and one looks at, and the court actually referred to Section 27(3) that says that the maintenance court may, only upon application in the prescribed manner, set aside the warrant of execution if the maintenance court is satisfied that he or she, that's now the respondent, has complied with the maintenance order in question. So the arrear maintenance still needs to be paid before he could approach court. Now, the learned judge then remarked that it is clear from the wording of Section 27 that the legislator saw it fit not to afford the applicant a right to a notice before the issue of the writ of execution was issued, and subsequently dismissed the appeal. So why is this important for us? As legal practitioners, it basically means that without giving notice to the respondent being in arrears, you can actually attach movable property or even financial instruments such as a life policy or that has a surrender value, or for example, any from the financial institutions such as Discovery, where there's an annuity or there is any financial instrument that has a cash value without their notice. Like in the VDB case, where the respondent only got wind thereof after he received the SMS message that a huge amount was deducted from his policy or from his annuity. So that is available in terms of legislation. Now we come to, that is basically warrants of execution in a nutshell. Now, just in general terms, the warrants of execution are a lengthy process. It takes a while. It's not something that happens overnight. It's not something that you can enforce, and it could be enforced very quickly. It usually takes a process. The sheriff of the courts are only doing in the big cities at least once a month they do the auctions. In the rural towns, there's a lapse of 3 months that would happen before they have where they hold public auctions, which might mean a delay. Obviously, the cost involved there would be quite enormous, because if they only do in the rural towns up in the country, or in the Free State, or where the towns are very far apart, if they only have auctions every 3 months, then the cost for storage might be quite a considerable amount. So the warrant of execution process is not a quick fix. It is not a process that you can do immediately. Although, having said that, if you know of the respondent that might have any financial instruments, pension fund, or annuities with a cash value, or any investments at any of these financial institutions, then that might be the route to follow, if you know that they do have those type of financial instruments available. Next, as part of attachment orders, we have to deal with Section 30, that deals with the attachment of any debt as contemplated in Section 30. So if one looks at this, and we're nearly running out of time, but we'll run through this quickly. Section 30 says that attachment of debts, a maintenance court may, upon application, again, there's an application form that needs to be filled in, the J306. Then the court can suspend the warrant of execution and then make an order, the emolument attachment order, and then make an order for the attachment of any debt. Listen to the wording: any debt at present or in future owing or accruing to the person against whom the maintenance order in question was made, and for the amount that is necessary to cover the amount that he has failed to pay, with other words, the amount that he is in arrears for, together with interest, as well as the cost of such an execution. So in practical terms, and this is sometimes not very well understood, so how does this attachment of any debt? Some of the magistrates reckon that if you need to attach investments, that is considered to be debt. In my view, my personal opinion is that it is not considered to be a debt. So Section 30 could not be used. It should rather be immovable property in terms of a warrant of execution used by Section 27 rather than Section 30. And I mean, the VDB case that we just discussed a couple of minutes ago is quite testimony to that Section 27 should be used. So in terms of Section 30, where you deal with attachment of any debt as contemplated in that section, I made it a little bit graphical so that we could understand what is meant by that. So we have a situation where the respondent borrows money to somebody else. He gives to his best buddy, he gives a certain amount, 100,000 Rand, just for example. So he borrows the money to somebody else. So that loan amount, that 100,000 Rand that he borrowed to his best buddy, needs to be paid back to the respondent. And that could be debt that is due at present, or it might be future. So they could come to an arrangement, I'll pay you back within a year, or whatever the case might be. So that is debt that is either present or future owing. Now that money, that 100,000 Rand, that in terms of Section 30, the court may make an order that the debt owed by the respondent not be paid over, or that is due to the respondent, not be paid over to the respondent, but be paid over to the complainant in order to satisfy the arrear maintenance. So what basically then happens is that the court would instruct this friend that has the money, the 100,000 Rand that he needs to pay back to the respondent, in order to tell him, do not give it back to the respondent. That money needs to be paid over to the complainant, to the mother in this case. And that only happens if there is an arrear amount and the court actually authorizes that in terms of Section 30. That is, in short, the attachment of debts. Do we use attachment of debts in practice quite a lot? No, we do not. In very, very extenuating circumstances, we would use the attachment of debt, unless you know that there are big services. You know what, the respondent delivered a service. He built a house, for example. I had a matter where he built a house, and there were certain amounts of money that was still due to him in terms of the building contract. And he had to get 1.5 million rand worth of services, that invoice. We could, in that instance, make use of Section 30 to attach the debt that was owed to him in terms of services that he provided, in order to pay the money over to the complainant. So that is also possible, and that is the situation where one would use that. That is basically the attachment of debts. Just a couple of general remarks regarding the attachment of any debts. As contemplated in Section 30, obviously the attachment of debts needs to be authorized by the court upon application. Again, it is an application that you need to bring to court. You fill in the J306 form, and you instruct the maintenance officer that there is money due to the respondent that could be attached. At present, there's no current form that is used for the attachment of debts, and the magistrates usually just make a note thereof on the record. It's not like emolument attachment order or garnishing order or warrant of execution, where there's a prescribed form. So the magistrate would just, on the record of the proceedings, just make a note thereof. Obviously, if the, for example, which we had in my matter, where the builder had to pay the money over, he could also bring an application for the suspension or the amendment or the rescission for the attachment of that attachment of debt order. There's a certain form that needs to be filled in, the J458, and then he needs to show good cause why the attachment should be amended or rescinded. And in very, very, very little cases do these type of applications succeed, because there's still a liability to pay the arrear maintenance, and going on to, very similar to Section 27, where the courts would cast a dim view of suspending such an order if there is still amount of maintenance which is left unpaid. That basically brings us to the end. Before we get to the end, I just want to note on future maintenance, and we've alerted that, and we had a full webinar on future maintenance. But it says, and it falls under attachment orders, and I felt it quite appropriate to remind the people thereof that any pension, annuity, gratuity, or compassionate allowance or similar benefit can be attached, notwithstanding anything contrary to the law. And that was specifically mentioned in terms of Section 26(4) of the Maintenance Act, and it was amplified by the judgment of Soller versus Magistrate Weinberg in 2006. It provided that, there is a mechanism where you can attach a pension, gratuity, or any allowance benefit that is due and payable, but it should be due and payable to the respondent. That is basically the future maintenance as well. Thank you so much for joining us. This was, my name is Eugene Opperman. I'm a family law practitioner. I've been doing so for the past 23 years, with obviously maintenance, my biggest passion, as well as domestic violence and matters pertaining to children. If you've got any comments, any questions, and so forth, please drop us a line at info@lunchandlearn.org.za. We would love to hear from you. Please tune in for our next webinar, same time, same place, next week. Thank you so much for joining us. Enjoy your afternoon further. And just as a last word of thanks to our candidate attorney, Erin O'Neill, for compiling the handout. I hope you enjoyed this session. Like I said, please drop us a line, drop us an email, giving us your comments, your feedback, which is always highly appreciated. Nice to hear from the people out there all over South Africa. Thank you so much. Thanks for joining us. We'll see you next week, same time, same place. Have a good afternoon further.